Right now, we're going to be talking about some of the big issues in our country this morning. My guest is seated, the Member of Parliament for Not Die, Roxanne. Oh, not
Die is Joycelyn.
Yeah, South Die. I beg your pardon. I was giving you a different constituency.
Indeed. Though we are a sister constituency.
Okay, but thank you so much for your time. Thank you for being here this morning. It's good to have you. I think it would be appropriate for us to start with AMERI because it's unbelievable that Dr. Kwabena Donkor will make himself available to the Mines Energy Committee, and then afterwards you come out with a decision that you're not going to be either cooperating or make yourself available again. I'm not sure I get it.
First of all, let me seize the opportunity to say good morning to my people in South Dai, Peki, Kwali, Tongo, Beve. Now, we made a decision a long time ago, and Dr. Kwabena Donkor's appearance before the committee is not as a result of he representing the minority view. He was invited in his capacity as the substantive minister when the deal was struck. And as you may be aware, the committees of parliament have powers equivalent to that of a high court. And so if you are invited, out of respect for the said invitation, you ought to appear and give them any information that will be relevant for whatever deliberations that are ongoing before them. And so he appearing before the committee was not symptomatic of representing the minority on the committee. The committee invited him, whether or not.
But he is a member, right?
Yes. But whether or not he participates, the minority participates at the committee level, the committee can decide to proceed with their work, and that is exactly what they are doing. And so the minority, we made that decision long before Dr. Kwabena Donkor was invited. And when
but he's a member of the minority.
Yes, he's a member.
How would you make such a decision and he would still go ahead?
He didn't go on his own volition. He was invited, and like I said, when the committee of parliament invites you, every committee of parliament is the speaker's committee, and like you see from the public accounts deliberations, they will tell you that they have the power of a high court.
Okay, so
when you're invited by a court, you have to attend. It amounts to a subpoena.
So did the minority sit through that session?
You know.
Is he done appearing, or
he told them, he gave them a condition. He said they wouldn't want to do an in-camera deliberations before them. He wanted to be covered live, or the media should be present before he speaks to the issues or the questions that they may pose to him.
Is that to say that he didn't answer any questions, or he didn't give them any information when he appeared?
I think so. I haven't spoken with him since Friday. But the information I have is that he told them they will not prefer an in-camera hearing. He will want whatever deliberations that will take place to be.
But if you look at the Daily Guide,
yes,
the front page of the Daily Guide newspaper, they say Kwabena Donkor grilled. Where's the paper? I'm trying to find the paper in a bit. Okay, yeah, it's it. Minister grilled over $510 million. You
can trust Daily Guide to do this. Indeed, you can trust Daily Guide to do this. So
let me read a bit of their angle. After 2 hours of grilling of the former Minister of Power, Dr. Kwabena Donkor, by the Mines and Energy Committee of Parliament at its special sitting to look into the AMERI energy contract on Friday, the ex-minister conceded that the Africa and Middle East Resources Investment Group was smart in making a windfall of $150 million from that contract. According to him, it will not be out of place for the new Patriotic Party government to re-engage AMERI Energy and renegotiate the contract, which yielded the windfall of $150 million from a $510 million contract from the company. AMERI later gave the contract to Power project is, and we know, the rest of the story. But the point is, maybe in plain language, for the rest of the citizens, we've gotten ourselves into a deal, and if a member of parliament who supported the deal before now says that he's got documents to show that not all the information was disclosed at the time. So now he has new information that suggests that we got a bad deal. I mean, are you not also citizens of Ghana, as in the minority in parliament, that you would not want to cooperate with such a hearing, so that if we can get ourselves out of that deal or get a refund, possibly?
It has always been our position. Don't get the minority wrong. And that is the slant that most of the media houses place on the position of the minority. The minority is saying the position taken by the government to, as it were, push for a rescission of the contract is not born out of good faith. And that if it is to the effect that the contracting parties are willing to review the contract downwards so that it will save the country some money, we are all for it. The position of K.T. Hammond in this matter is that he has since discovered new information or documents that borders on fraudulent misrepresentation. And fraudulent misrepresentation, my dear, when you are alleging it in terms of a contract that has already been executed, Parliament is not the forum.
But is it Parliament interested in at least hearing?
Yes, but Parliament is not the forum. Parliament has no capacity to make a determination that a party has fraudulently misrepresented information to it. We have no such capacity. It is the judicial forum.
But to the extent that you started this deal, this deal started with you,
it is immaterial.
are you not even interested in just discussing it? Let's see what you say you have.
That is why when they brought the motion, we say we want to debate the motion. They say no. We want to debate the motion. How do you move a motion and we are not allowed to debate the motion? And the motion is quickly referred to a committee. We are making the point, and it appears nobody, because you see, they have already taken a decision and they want us to deliberate on a decision that has already been taken. But things don't work like that in Parliament. You deliberate before you make a decision. Go to a court. When you are alleging fraud, it is a matter of fact. So you have to go to a court for the court to interrogate the issues, whether or not indeed the party that you are alleging fraud against indeed fraudulently misrepresented some facts to you, based on which facts you made a decision to execute a contract. How can Parliament come to this determination? How are we going to do it? He claimed, as I sit here, as a member of Parliament, he raised this matter before we rose the last time. I have never cited a single document to that effect. But it's all over the place. So nobody should make the mistake that we are not in favor in participating in deliberations that will save the country money. No. We are saying the route that is taken, you don't do so in Parliament. You have to sue.
So as members of Parliament, you make the laws.
Yes.
And if you get us into a deal,
yes,
based on possibly misinformation, yes, are you not interested in it? I mean, can't you also pursue it?
Now, let me ask you something. It is a constitutional prerequisite that any international agreement that the government wants to enter into receives parliamentary approval. And very often, because of exigencies of executive work, sometimes the agreements are executed before they are brought to Parliament, or sometimes the agreement is brought to Parliament before they are executed. Okay. Now, what K.T. Hammond is doing in the event that even the agreement is rescinded by Parliament, does it therefore mean that the government will go back and say that they are resailing from the agreement because Parliament has withdrawn, as it were, its approval? No, I'm asking you a technical question.
I get you, but is court the only option? What if, in this case, what if AMERI is ready to have a conversation?
Good. You see, that is why we have made the point that now there are two parties or more to every agreement. Two, opposite side. In law we call it addendum. You said that there was a meeting of the minds at the time you were executing the contract. If any extraneous factors have since been discovered to torpedo the existence of the agreement, it is the parties that must meet. If one party is so aggrieved that he is unwilling to meet the other party over the matter, then the judicial forum is the forum convenient. You don't no, what he's doing is a facade. How do you, okay, if Parliament withdraws its approval, as it were, what happens to the agreement? The agreement
there's no agreement then.
Who told you that? The agreement has already been executed. You understand me? Parliamentary withdrawal of approval does not negate the agreement.
So what's your suggestion?
It does not negate the agreement.
He has something to prove otherwise.
What
should he be doing? What should we do?
I have just told you that he claims he came to Parliament that day with some papers in hand. I am here to cite those.
You said you haven't seen.
He was asked to table the papers at the table office. I am here to receive a copy. Several months.
Well, was it because you probably have not been available in Parliament?
No. Parliament doesn't work like that. When papers are tabled, they are distributed to each member for his or her perusal. So
how should we, and we're not talking minority here, help us, Ghanaians, how should we perceive this new information that's coming up?
Beautiful. Some work had been done by the Addison Committee. Where is that report? What is that report saying?
You haven't cited that report?
I cited it in cyberspace. I have not cited the hard copy. So I am minded as to how much probative value I place on it. But if indeed they've done some work, they should release that report. And let us look at the merits. If indeed the other contracting party, which is AMERI, are willing to come back to the negotiating table, beautiful. But don't do things to bastardize the government at the time. And that is the agenda.
So is that how you interpret it?
That is the way we say it. Otherwise, what is the hard and fast rule about calling AMERI that, oh, AMERI, it appears that at the time we were contracting, we were going through the negotiations, you made such certain suppositions. Which suppositions, new information we have received suggests that they were not entirely correct, or suggests that we must relook at those issues. If they are not willing, then you sue to disengage from the contract. If you are indeed so aggrieved that you want to discontinue with the contract. But if you are willing to continue with the contract, which they are doing now, go and check. Ministry of Finance is paying them. The only thing they are doing is that instead of paying them about 8.5 million a month, they are paying them 6 million. So that by their own computation, there will be a shortfall of 150 million. That is the money they have been bandying about.
But what is AMERI saying? They are receiving and not complaining, are they?
They are complaining. I've cited a few letters regarding that shortfall.
What does it say?
Oh, that instead of paying me X amount, you are paying me Y amount. And you haven't advanced any reasons. So we must abide by the terms of the agreement, so that monthly you have to pay me this.
Is there an or?
No, I haven't seen an or there.
Okay.
It's just a reminder. It's just a reminder.
How much communication has been going back and forth?
A lot. You mean between AMERI and the government of Ghana? A lot. Ever since the Addison Committee finished their work, there've been a lot of discussions. So these circles in Parliament
Where do you see this ending?
Nowhere, except
it's not going to go to court?
Except to serve a political agenda. Why?
But to be fair, to Katie Hammond, he was the only person then in the minority that supported this deal. So
no.
If it's come out, he wasn't.
No. You see, this is another misconception. Is it? Things don't work like that in Parliament, and let me show you how things are done in Parliament. When such a document is submitted to Parliament for ratification, for approval, it will be referred to the appropriate committee, and in this case, the Mines and Energy Committee at the time. After the committee deliberations, a report will be prepared, and all committee works. Every report by a committee of Parliament is the Speaker's report. So the report will be brought back to plenary. That's the whole house for further deliberations and approval of the report. Once that is done, it ends the matter. Now, by convention, when the chairman lays the report, or in his absence, any deputized member lays the report on behalf of the chairman of the committee, the ranking member is from on the other side. So
is this where Casey Hammond comes in?
Yes. So it is not because he was the only person. He was the ranking member at the time on the committee.
Well, but if he didn't believe in it?
Sorry? He could have said so.
Yeah, so that's why I'm trying to say that at the time.
So nobody should say that it was only Katie Hammond who supported it. Because by convention, he was the ranking, supposed to support so you say that, Mr. Speaker, arise in support of the report of the committee. But in doing so, you say A, B, C, D. You could make your reservations known and still support.
But I'm not sure he had any reservations at the time. Good. Because he had every belief in what he had seen at the time.
So what is informing his position now?
Well, that's what he's been telling you, that he's got new information.
Have you seen any document? I am asking.
Well, I haven't, but you are a member of Parliament. You sit there with him.
I haven't either. That's the point I'm making. That they are battering the matter in the media space.
But the fact that you haven't seen it doesn't mean it doesn't exist.
Why should I believe it? If up to now you have not preferred any document, he's not publicized any document. Even if you won't give it to members of Parliament, make it available to the media. Let us be speaking to some documents. You are not doing so. So
this won't end anywhere.
I think it's a circus. It's a circus. So they should go to court and interrogate the matter of fraudulent misrepresentation in this case.
There's AMERI fighting back. Maybe let me just continue with that as well.
Still reading from the Daily Guide.
Well, you have a problem with me reading from the Daily Guide.
Because no journalist was before the Mines and Energy Committee on the day Dr. Comrade Donko was supposed to have spoken.
Correct.
And yet, see the kind of account as if it was a first-hand account.
Well, so what, are you doubting what they've written?
Why wouldn't I doubt?
People have their sources.
Sources. Did they say so?
Well, meanwhile, AMERI says its 2015 agreement with Ghana for the provision of a power plant offered, quote, the best value for money, despite the $150 million rip-off claim. AMERI, in a statement following an appearance before the Mines and Energy Committee on Friday, said the government has the right to review the deal if it feels it is being ripped off. Quotes, AMERI acknowledges that the government of Ghana has every right to assess all public contracts for value money or quality of delivery. The company strongly believes the project delivered on both. And independent reports by renowned auditors, PricewaterhouseCoopers, okay, that's also the continuation of that. That we know already. According to the committee charged to review, restructure and recommend areas of amendments of the AMERI Power deal, the company, in its agreements with the government dated February 10, 2015, is said to have charged Ghana significantly higher than what it was charged by the Turkish company. Okay, so that's the story. You can catch up with it. There's also the Katie Hammond angle also all in this story. But as we know, the minority is not interested in talking about this matter at all, not in Parliament. So if it happens that this appears in court, then you'll be interested in...
Indeed. Indeed.
Okay.
Let somebody sue.
All right.
With whatever information they have.
But it's not like you're on AMERI's side in any way.
No. We're only saying that at the time the deal was struck, that they had all the appropriate, all the due diligence and the most effective routes were taken. There were three other options. There were three options available when they were doing this. Are you aware?
Yes.
You are aware?
I think yeah.
Okay. So
there were,
three options for the...
This is what we...
for the
but
GOG
you see,
at the
I
time.
think we went through a middle person because we didn't have the money.
Yes.
Okay. All right. Let's leave this matter and see where it would go from here. But are you expecting that this matter will come to the entire floor again?
Yes. The committee will bring its report when they are...
When?
Or I should think maybe next week.
But you're not part of the committee sitting. But you're interested in knowing the outcome of the committee sitting.
No, but I'm a member of Parliament. When I'm like I'm a member of the Constitutional, Legal and Parliamentary Affairs. The Special Prosecutors Bill has been referred to us. We've done a lot of work on it. I'm sure by Wednesday we'll lay the report.
Oh, really?
Yes, and then we'll debate the merits of the report.
Okay, let's get to that bill for a while.
Yes.
Just allow me. What's different about this one that's brought to the committee this time around?
Exactly our position. There was nothing really different. It was a matter of procedure, the constitutionally defined procedure to follow. When it was initially laid, was not complied with, and that was when we raised the issue, and in a very clear manner, others are saying that at the time they brought the bill, they didn't even say that it was supposed to have been taken on a certificate of agency, which is not correct. That was exactly the expression they used.
So,
you know,
the way
but
it's
they
been
saw
brought
wisdom.
now,
They saw wisdom later on. They withdrew it to allow it to mature. For the stipulated number of days, after which it was relayed late July before we went on recess. And so since August,
it's been counting. No,
yes.
Since August. I thought
no.
it was withdrawn.
What I mean is that it was gazetted in April, or a date in June or so, but they didn't wait for the stipulated number of days to mature before it was laid.
That's okay.
It was short by, I think, 7 days.
Oh, okay.
Yes.
So it means that we have to start the entire process again.
Which we have done. They have done. They've regularized that. It was properly laid this time in July, before we rose at the end of July.
Okay.
And so since August, September, and in October, the committee members will be very, very busy.
Okay.
On the bill, we've been very, very, very busy.
So what are some of the conditions? We heard a few things.
Conditions
There's still a fixed tenure, isn't it?
As to
the independent prosecutor.
You mean tenure of office?
Yes.
Yes, 7 years.
7 years. Okay.
Yes, eligible for reappointment for another 7 years. But these are all at the bill stage. When it comes to plenary.
Yeah. So this is the president is it in consultation with another body, or this is the president solely appointing the special prosecutor?
You know, even at the committee stage, there have been a lot of deliberations. There have been a lot of proposals to the original process of appointment. She was to have been nominated by the Attorney General, by the existing Attorney General, and then appointment nomination confirmed by the president.
Okay.
Okay. Now, the further deliberations to this, or further amendments at the committee level, was that if the discretion to nominate somebody as a special prosecutor is reserved solely in the Attorney General, it could be a basis for, abuse. Abusers in the cronies and acquaintances could be appointed. So, for instance, if you read the proposition by CDD Ghana, they are of the view that before even a person is nominated by the Attorney General to be appointed by the President, that nomination process ought to be open to everybody, every Ghanaian so qualified. And that once you publicize the vacancy, interested and qualified Ghanaians will apply. Then there will be interview or examination and all whatever mechanisms so that there will be, it will seem open. The appointment process would have been fairly open and not shrouded in secrecy. But if you say that the Attorney General should wake up one day and nominate Mamavi to be appointed as the special prosecutor, and once she does that, the President will only go ahead and appoint the person. So CDD Ghana is saying that, for instance, publicize the vacancy, receive applications, interview the people, go through a short list. When you do a short list, then you can nominate somebody from that short list.
But for an office like that, if you open it up, would you find people who are properly qualified, so-called, coming forward?
Why not? There are a lot of seasoned lawyers who have done a lot of criminal practice.
That they will voluntarily come forward?
Yes, because you see,
I thought we will go poaching.
No,
rather.
Because you see, if you are not careful, you are opening up yourself for litigation. When I am 12 years at the bar, and I think that I want to be the special prosecutor because I am qualified. And yet, by the nomination and appointment processes that you have statutorily defined, does not open it up for me to participate in the process. I can go to court and test it. That it is against my constitutional right of fair employment, equal employment. All right. To be offered, to have opportunity to be recruited by the state, but I was not offered that opportunity. So to avoid all this anticipatory litigation, open the process up, let people participate.
But the bill itself, does it outline all these things?
So further amendments have been suggested. So when we after the approval, after the laying of the committee's report, will be debated, and once it is approved by the House, then we'll move to the consideration stage. That is where we'll effect the amendments.
Oh, okay.
And I can give you a few that I have filed personally.
Oh, please do.
I will. So that is where we are in terms of the OSP.
In terms of the what?
OSP, Office of the Special Prosecutor. That's how we've come to call it.
Oh, okay. We just call it the Prosecutor's Bill.
So the acronym is OSP.
Okay.
Okay, Office of the Special Prosecutor's Bill. Yes. So these are some.
So on Wednesday we should hear something on the floor.
It's if it makes it, it will change a lot of things in this country. And I fear.
You fear?
I fear.
You fear for who?
I fear for everybody.
How is that?
Because it's an octopus. It's an octopus coming.
But if you haven't done anything wrong, if I haven't done anything wrong,
let me give you an instance. A phrase has been used in the bill, and it's called politically exposed persons. Now, in the interpretation section or clause, politically exposed persons are defined as persons who occupy public office, whether in this country or on behalf of this country and outside.
That's the definition the bill has given it. Okay.
So to speak, I don't have it on top of my head, but to the effect that public servants or persons who occupy positions in political parties, either within this country or outside of the country on behalf of the country. So UN, if you are appointed to represent Ghana in the UN and all those things. And they are friends and acquaintances Associates. So, Mama V, as you sit here, you are my friend. I consider you a friend.
Thank you.
If I get myself involved in a corrupt act, all right, the law is saying in arresting me, you will also be arrested. Or in investigating me to establish the veracity or otherwise, to establish a prima facie case before I am prosecuted, you too will be investigated. So your wives, your children, your friends, your acquaintances, associates, they are all defined as politically exposed because of your connection to me, the politician.
Just a connection to you, or
yes,
maybe with regards to the particular claim?
No, just your connection to me. So once I am involved, I am implicated in a corruption act or a corruption related offense,
then possibly any close person.
Yes, it's not possibly. That's what the law is saying. There's no possibility. That is why I'm saying I fear it's an octopus coming, and a grand one. It will reach every nook and cranny with its tentacles in this country.
So what's your objection to that? I mean, in what way can we put that?
I have no objection. I am only hoping that the way they are exuberant in trying to ensure that this particular phrase stays in the law will be applied as they intended. Because you see, the other difficulty is it is part of our criminal jurisprudence that another cannot be responsible for the crimes of another. I cannot be responsible for your crimes. It used to be the case, but he has since about 1970.
But you said on the constitutional, this committee that this has...
Yeah, constitutional, legal, and parliamentary affairs.
So does this conflict with the Constitution?
Indeed. To be held liable for the crime of another is unconstitutional.
Well, to the extent that it conflicts,
good.
then...
Yes, good. But you see, when I raised the issue, I was told that it is already part of an existing law, that is Anti-Terrorism Act. So they just lifted it from the Anti-Terrorism.
So let's go to the Supreme Court then. Let's go and get some interpretation.
I agree with you because, look, as I speak about this particular clause in this studio, I shudder. I am...
Why are you... Like, I still don't get it. I mean, if the people close to you, if they are interrogated, and they have nothing to do with the particular crime that you're being accused of, then they go free. You
see, in this country, if you have an unscrupulous special prosecutor, all right? If God forbid, if we are ever given an unscrupulous special prosecutor who has a fixed tenure of office 7 years, and his removal is as difficult as the removal of a court of appeal judge, and decides to go after you or after anybody, all they have to do is that somebody should make a complaint, or they must have a reasonable suspicion, as the police do, reasonable suspicion that you have engaged yourself in a corrupt act.
Isn't the same thing? Isn't it what Iyoko also does?
Yes,
I mean, it starts with the investigations, right?
This is more vicious than the Iyoko Act.
Is it?
It is.
Is it not an investigative body? Is it still not an investigative body?
Yes, I am only saying if you have an unscrupulous special prosecutor who can decide that, for instance, I want to go after the Santehini, for instance. Yes. You see, you are saying, No,
I mean, okay.
You understand me? Let's say, for instance, what happened last week. Based upon that news reportage, then he decides to move, only for it to emerge a few days later that no, there was nothing wrong.
But
he would have embarrassed the king. But an unscrupulous special prosecutor who want to do that.
But the special prosecutor,
because you see, the law talks of private citizens.
Move like that? I mean,
the law gives him power. He says that upon reasonable suspicion. Upon reasonable suspicion.
But what's the beginning of an investigation? It's not an invitation.
No.
Is it a straight away arrest?
By this law, even before the investigation commences, they can be freezing assets. They are freezing orders. First, they seize the assets, they freeze, and then they dispose of when you are convicted. So the kind of embarrassment it can occasion you is what I speak of. So
that's what you're afraid of.
Yes, and I'm saying,
but if you don't
have a special prosecutor who is level-headed, then we are in for trouble.
Well, we have to scrutinize well and make sure that we have
exactly our position. That is why we are saying that Attorney General alone, suo motu, alone, on his own or her own discretion, should not just handpick somebody.
So what's the proposal?
The proposal is what I spoke about.
For the president to make the appointment.
The proposal, the expanded proposal is what I spoke of.
Open it, let
people apply.
Okay.
Let people.
So who does the interviewing? I mean, what kind of panel?
It's still the office of the Attorney General.
So is it not going to come back to the same thing?
Yes, but at least there would be a semblance of wider participation.
One that the minority is going to accept and agree?
It's not about the minority. It's about the Parliament of Ghana.
The Parliament of Ghana is made up of minority and majority.
Indeed.
And we know in times like this.
No, on matters like this, it's not about minority, majority. It's about the law serving the interest of the people with the true intent of Parliament. And not to be used to harass.
Is the committee divided on political lines?
No.
With what you've seen?
This is about 90% professional. It consists of about 90% lawyers with this committee. So when we deliberate on matters, we do so stricto sensu legal.
Okay.
You know, we speak law, we talk law.
Okay. So we hope that what will come to the floor would be true representation of what the committee, thinks about this whole bill. We'll be looking forward to it.
The committee will only bring a report. But it is the House, it is plenary that will enact the law.
Yeah, but you would have done the greatest job. The committee would have done that.
Still, plenary can work to change even the structure of the bill.
Yeah.
There's
another bill I hear you're making some corrections to the Zongo development bill.
Amendments.
Okay.
Yes, they are all bleeding. All the bills are bleeding.
Why is that? Was it rushed?
Perhaps.
So what are some of the things that you're correcting?
Phraseology.
Okay.
That's drafting. So phraseology, structure of the law, content, context, and meaning of words.
Basically everything about the bill then.
Yes. But a properly drafted bill won't suffer that. You won't bleed much and it goes through. But if it's not properly drafted, if it's rushed, or you don't consult, normally you propose a bill, but you have to do wider consultations so that by the time you get to the House, the bill is healthy.
So whilst you do your work as a committee in Parliament, the citizens, is there something that we can do?
Yes.
Or we just...
At the stage that you require the input from the citizenry, is long past.
It's not passed.
Yeah, they did some stakeholder consultations, and that was when they claimed that they had consulted with civil society groups.
I'm talking about ordinary citizens.
Yes, but you are supposed to do, because if they don't offer you the forum, you won't have the opportunity to participate. That is how unfortunate it is. And I don't know how well publicized some of these forums were, and even where they were held. But they came to us in Parliament before the committee level. So you see, they met us as parliamentarians before they referred the bill to the committee.
That's the proper thing to do, isn't it?
Yes.
I want us to, we've spent a bit of time on your committee work, but that's good. Let's finish off with this radio stations. I mean, it was big news when some radio stations were sanctioned. The news today is that for the community radio stations, it's been lifted. There's a waiver, a complete one. But for the commercial radio station, it's been slashed to 50%. The figures are still huge. What do you make of this?
It's supposed to be good news if the basis for applying the penal sanctions were legitimate. But we have since discovered that they had no basis to apply the new schedule of fees that they are seeking to rely on, because they took an executive decision to come out with a new schedule of fees, gazetted it without recourse to Parliament. And that is unlawful.
This was done when?
This was done, I think, 2000. I think the new scale of fees was prepared in 2015. And when they came, they gazetted it and sought to apply it.
So we're not even talking about this administration.
But it was this administration that gazetted it and sought to apply it.
Illegally?
Yes. And so the principle in law is ex nihilo nihilo fis.
What does that mean?
It means that you can't put something on nothing and expect it to exist.
So this is null and void?
Yes. So when she came before us, we made a point. We deliberated on the matter heatedly.
Was it deliberate though? Was it deliberate because you knew this day could come?
She's a lawyer. She's and I respect her.
No, in terms of why would you want to put an executive instrument through and not, go through the proper channels?
It's curious. That's why we felt that it was something they thought they could do and get away with it. Or maybe.
So what does this mean to this news that we are hearing today about a waiver? And
yes, that's why I'm saying that it would have been good news. I would have been praising her if the decision to waive is legitimate. But now she has no power to waive at all.
If you are a lawyer, there are a lot of radio stations that you mentioned: Radio XYZ, Atenka, Radio Gold, Atlantis. If you go to Kumasi, there's Price FM, Des FM, Hello FM, New Mighty Radio, Zuria FM, there's Cape Coast FM, Katinka FM. You are their lawyer. What would be your advice based on this?
I'll sue to torpedo this.
You sue who?
I sue NCA to torpedo this. You sue the Attorney General. You sue the government of Ghana.
I thought you would sit back and say, I won't pay, and then let them do their worst. After all, there's no law.
No, they'll cut you off. They'll take you off air.
Yeah.
So you don't have to wait till it gets to that. You sue because you are aggrieved.
So you're aggrieved at what?
You are aggrieved that they are applying a scale of fees that has not received parliamentary approval, so it is unlawful constitutionally.
Remember you said something that sometimes, but this was in connection with international agreements.
Yes.
So could this come to Parliament for?
No, this is not agreement. This is tantamount to levying taxes. So to levy a tax, to levy a fee, to receive money from people, entities on behalf of the Republic, Parliament must approve of it. Otherwise, Mama V, you can also wake up and say, you are developing a toll booth in front of Joy FM, you collect toll and pocket. You understand what?
No, but we're talking about this is an authority.
Yes.
This is a government agent.
That is what I'm saying, that any entity, whether private.
So how can they correct this?
They must bring the scale of fees, the new schedule, to Parliament.
And then if it is approved?
For us to approve.
Okay.
If we approve, it's just like university fees. The fees
so if it is approved, can they then go ahead?
They cannot apply it retroactively. It will be going forward.
Oh my God.
That's the beauty of it.
Interesting times that we find ourselves
in. They are rushing with a lot of things.
So this is no news?
No, and they are running into hurdles. They are running into roadblocks, legal, constitutional and
but
all.
As you observe as a parliamentarian, as the legislature, I'm not even talking about minority here.
I agree.
And you've seen something, you've seen an illegality.
Yes.
What can you do? What are you interested in doing? What should we expect you to do?
We pointed it out to her on Thursday
Just last Thursday?
Yes. She came to the house with a statement concerning this matter.
And this decision was taken on Friday?
Yes. It was because the MPs told her plainly that, no, you can't do that. So she thought that she could then go back and review. But she has no power to review.
Should we expect you to raise this in Parliament on the floor tomorrow?
Yes, indeed. She has no power to review. There's nothing to review. She should bring it for approval.
But it's interesting. She's also a member of Parliament.
Indeed, she is. But you see, when you go into executive, there are a lot of factors
Executive power
that can blind your judgments.
I think we've had a very fruitful conversation. I've absolutely enjoyed it. Thank you very much for the insights.
It's my pleasure as always.
We'll see a lot of things on the floor of Parliament this week, I guess.
Particularly Wednesday.
On Wednesday.
When we'll be laying
the prosecutor's bill.
Yes.
The
report.
The reports.
Yeah. Oh, it's been laid already. But the report from the Constitutional and Legal Parliamentary Affairs Committee.
Thank you very much. You're also on the Judiciary Committee, is it? Okay. There's an issue of judges, the judiciary not receiving some payments, blah, blah, blah.
Not judges alone. That's judges on the lower bench, the magistrates and circuit court judges, judicial service staff. There are issues. There are issues with admissions to School of Law issues. So we are planning to take those matters up pretty soon. Okay, but the judiciary, they're not striking, are they? There was some news on you can't, the judges cannot strike. You know, that's one other problem we are having. We are asking them to deal with is that they must divorce, they must detach the judiciary, quasi-judiciary from the judicial service. Like the local government and local government structure.
That sounds a bit complicated.
No, there's a local government service.
Yes.
And there's local government.
Yes.
We are asking them to go along the same line because when you are dealing with judges, superior court judges, they are what we call the judiciary or judges, who are judges. And constitutionally, you can't vary their conditions of service to their economic detriment. You understand? But when you bring me an estimate to Parliament to approve,
for the entire judiciary, including the administrative,
service
all right, okay.
You are, you know, it's murky.
So that's the recommendation.
Yes.
All right. Okay.
So I'm sure when we are dealing with them, we know exactly how to handle.
Yeah. Well, thank you for your time. Thank you for spending time with us this morning. That's Member of Parliament for South Die. Never again, Mr. Roxanne Nelson. Dafiamapo, thank you very much for your time here on the show. Pleasure.